Jefferson County Court at Law number 2 is back in session. In session with clause numbers 326-996 and clause number 332-430. Both cases are style of state of Texas versus Glenn Paul Ballard. Mr. Ballard, that's your full name?
Yes, sir.
Okay, now, Mr. Ballard, where's the paperwork? Earlier, you, where's all this paperwork? It's a waiver and a judge's explanation. Hold on a minute.
What's that paperwork you want?
Okay, hold on a minute. Okay, Mr. Ballard, earlier you had indicated in your judge's explanation of rights to defendants without an attorney that you wanted to waive your right to an attorney and represent yourself. Is that correct?
Yes, sir.
And you and the state of Texas assistant district attorney could not reach an agreement regarding your case.
Yes, sir.
Now, the last paragraph in this judge's explanation of rights to defendants without an attorney states, if you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, do you still want to proceed without an attorney, or
Yes, sir.
are you changing? You still want to proceed without an attorney? Okay, now let me do this here. Okay. Okay. Now, Mr. Ballard, pursuant to Ferretta versus California, 422 US 806, I have some questions that I need to ask you. Have you ever studied law?
Yes, sir.
Have you ever represented yourself in a criminal action? Do you understand the charges against you in the information?
Yes, sir.
And what are the charges?
It's misdemeanor theft,
Okay,
class A.
okay, well, you have one class A and one class B. Okay, now are you familiar with the exact legal elements of the charge? Do you,
I mean, I understand what we had agreed on. You know,
you said what you agreed on? Well, no, when I say the elements, I mean, do you understand the wording of actually what you've been charged with?
maybe, explain to me. I think I understand.
I'm just asking you the questions right now. Do you understand? Yes or no?
Yeah,
Okay. And what other elements?
that's,
Okay, what are the, okay, when I say the elements, what's the definition of theft?
Judge, if I can, if, I'm sorry to interrupt, if I can jump in there, I'm happy to provide the defendant with a copy of the charging instruments in both of those cases.
Okay, well, I'm just right now trying to see whether or not he understands, pursuant to Florida versus California, whether or not he's able to represent himself. Now, so do you understand the elements of the charge, a definition of theft?
definitely what, taking something without being given permission. Take it. That would be
Okay.
the element.
Okay, that's, I guess you could say that would be equivalent to what's
Possession of
in.
it, you're not supposed to be in possession of it.
Okay. Now, do you realize that if you are found guilty, what the punishment can be?
I don't know what's punishment, I don't know what it is, but I know there's one. What is that, a year in jail, something like that?
Okay, and that's for the class A misdemeanor, okay. And I think during the arraignment, the court informed you what the range of punishment for class A misdemeanor, for class B misdemeanor, and class C, you remember that?
Right.
Okay. Now, are you familiar with the Texas rules of evidence and Texas case law?
No, I'm not.
Okay. Do you realize that the Texas rules of evidence and the Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules?
No, I'm not familiar with it.
Okay. So you're not familiar with how to conduct the voir dire, is that correct?
I'm not familiar with it, no, I don't understand it.
Okay, you don't understand what a voir dire is. Okay, that's good. And I would imagine, since you're not familiar with those rules, you're not familiar with what are the grounds for excusing a juror for cause, is that correct?
Correct.
Do you know what you're not familiar with what is hearsay?
Yeah, pretty much, I know what that is.
You know what hearsay is, okay. And do you know what some of the exceptions to hearsay are?
No.
Okay. Now, do you know what is proper to impeach a witness? And that is to discredit a witness?
No.
Okay. Do you know what is character evidence?
Somebody thinks about somebody else or.
Okay. Okay. Now, do you know, I would imagine you do not know how to offer evidence to protect the record for appeal. Is that correct?
Correct.
And you do not know the proper grounds for a mistrial?
No, I'm not sure.
Okay. And now, are you aware that that the failure to timely move for a mistrial may waive crucial mistakes made by the state or this court? Do you understand that? Okay. And I would imagine you do not know how to request or object to a jury instruction. Is that correct?
Correct.
Now, are you familiar with the Texas rules of criminal procedure? You're not.
No.
And well, do you realize that those rules govern the way in which a criminal action is tried in court?
Yeah.
Okay. Okay. Now, at this time, Mr. Ballard, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can be by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with court procedure. You're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. And now, in light of the penalty that you might suffer if you are found guilty, and just let me back up. Now, for Class A misdemeanor, as I mentioned earlier, the range of punishment is you could be given anywhere from confinement from 0 days to a year, 365 days in the county jail, a fine from $0 to $4,000. For the Class B misdemeanor, the range of punishment is 0 days to 180 days, which is 6 months in the county jail, and or a fine from $0 to $2,000. In light of all those difficulties of representing yourself, is it still your desire to represent yourself and to give you your right? Let me see. Is it still your desire to represent yourself?
Yes, sir.
And to give up your right to be represented by an attorney?
Yes, sir.
Now, is your decision entirely voluntarily on your part?
Yes.
And I find that you knowingly and voluntarily waived your right to counsel, and I will therefore permit you to represent yourself. Okay? Okay.
Yeah, I don't know if this is the appropriate time to touch on this subject, but if the defendant doesn't make bond by the next jail run, if we can have a state that's in the next jail run, I think.
You talking about Thursday?
Yes, sir. Well, not this Thursday.
Oh, that's right. We don't have.
I guess
Oh, that's right.
next
That's right.
Thursday.
That's right. We don't have.
If he doesn't make bond, I have a strong suspicion, because we went far away. I'm not gonna talk to you about the negotiations.
Okay.
We went far away. Work something out.
Okay.
Yeah.
Okay. So we'll reset it to that date.
If he doesn't make bond.
Yeah, if you don't make that. Well, give him a regular reset date. It's always gonna be pushed up, I guess. Or it could be pushed back. Well, if he's out, he could be pushed back. Put him on that date. And if he's not there, then we can always push it back. Okay. All right, Mr. Ballard, just follow the bill. Okay, and this will conclude the calling of the, let's see if we have any bond forfeitures. Gilbert, jail. Oh, got Bernard Colbert.
Did he go to jail?
No, didn't appear. Okay, just hold on a minute. We'll go over our bond forfeiture.